welcome back. You have until 9:30 tonight to send in your answers to the DFL giveaway. We're offering 2 of our viewers 50% off the cost of a consultation with any attorney at law. Once it is a consultation that will help you to produce a will. Just tell us why you think you deserve that prize, and we'll be choosing 2 winners tonight. I'm here with attorney at law Veronica Snack, and we're actually talking lots about wills, why we should and what we shouldn't be worried about, and so on and so forth. And you were making a very important point in the break, Veronica, regarding people thinking how difficult it is and how long it takes.
Yeah. It really doesn't take that long to actually get the will done. As I said, it's not very expensive. It would take you about 2 visits to your attorney's office. One to take the instructions, and the second visit is to execute the will with the second notary. The instructions take about 30 minutes, thereabouts, and then you come back, and the execution involves reading of the will in the presence of the second notary to ensure that the instructions are your intentions, are your wishes, and then the execution.
Can people come to yourselves, and I say yourselves, I mean the lawyers, and say, look, I know I need to prepare a will, but I really don't know where to start. I don't have very much, and maybe there's conflict in the family, because a lot of the time, you know, there could be, I'm not sure who to leave it to. I don't know who should be executors. I don't know. And when they come to you, I'm assuming it's all confidential?
Yes. Everything that an attorney does on behalf of a client is confidential, regardless of what it is. And wills in particular are even more confidential. You know, the attorneys, we always advise clients to ensure that you have informed a member of your family or close acquaintance, 1 or 2, that you have the will, because we don't send the will to a registry anywhere, so there's a notice of it. You have to know who your attorney is in the event of your death, and who has the will, so that will can be found, and it can be probated.
Now, we've mentioned the word probate. Yeah. Define that, please.
Yeah. Probate is, I suppose, technically it's a fiction of law. What it allows you to do, it allows somebody who is called the executor to stand in the place of the testator themselves. It's a fiction of law. In other words, I've passed, I can no longer act. Obviously, I cannot physically sign documents, etc. But I say that I want this person to represent my interest or my estate, and this is what I want him to do. The will specifies and says who gets what this is, what should be done, etc. The executor will be, once the probate is the grant of the legal interest in the estate to the executor, who has the responsibility of passing that legal interest to the beneficiaries or the heirs of the estate, who the executor might very well be one of. Right? Usually the executor is an heir themselves. It gives you an incentive to do everything that is necessary to ensure that the estate is administered. But that is what probate is. So it's an application that is made to the High Court. It can be, and it's generally made through an attorney at law. That is the part that is costly. Fortunately, we do not pay things like inheritance tax like in the US, but you do pay some amount of stamp duties on the value of the estate. Okay. Especially if it is, not movable property, but for immovable property, yes.
All right. And in St. Lucia, we don't pay what we know in England as inheritance tax.
No.
Okay, so what if someone like me, in terms of, you know, I was born in England, and if I had a property in England, but I now live in St. Lucia, I would still have to pay the inheritance tax because the property is in England.
In the UK. So the property, if it's immovable property, land, etc., it is managed or controlled by the law of that country. So yes, you would have to pay it in the UK.
All right. So are there any things that we can or we can't include in wills? Could I include something like, I want my neighbor to look after my horse or my cat?
Yeah, actually you can.
You can?
You can say, Well, you know, the will has to show that you are of sound mind. So you don't want to put anything that will bring that into
No,
question.
but some people
first of
think
all.
like horses are very, you know,
Well, yes,
important to
because
them. They
but
may
are-
want to not to leave it to their child because
Yes.
their child cannot look after it.
Right, that's why you
But the
can't-
neighbor can.
No, but you can't do that. You can leave your horse to your neighbor. It's like leaving a possession, and
Right.
an animal is a possession, so to speak. And yes, you can leave an animal to the care of somebody else.
But do you think a lot of people would, I wouldn't say they would come to you because you couldn't really tell us in that state, but when, do people worry about how much, like say they have little money, and how, if they have say 4 people and they don't have a lot of money, do they worry about should they give it to just one person, or do they give $20 to each person,
Yeah.
or should they just give it to charity, you know?
I think that's a problem, you know, that at the end of the day, most people cannot decide what to do with their estate. They might feel that they have, as you say, they have so little that it doesn't make sense. But why bother? I don't have land, I don't have anything, so why bother to leave a will? It does, you know, why pay a lawyer money for that? It helps because, again, at the time of your death, you never know what you may be entitled to, right? It could be that you were an heir in some 100 acres of land somewhere that you never knew anything about, and somehow, you know, it was discovered right before, you didn't take it into account, so you have this.
All right, you say that, but I mean, how likely is that? Okay, let's look at
Well,
the reality of it. Let's just say
there are cases, well, not in St. Lucia that I know of, but cases in the UK where that has happened.
yes. Okay, but let's if we kind of come home and we say, all right, then, Ma Felix lives in her, you know, her little home in the Mabuya Valley, and as far as she's concerned, all she's got is this little, you know, shack over her head, which perhaps her son in England bought for her. So when she passes away, it's maybe willed already because it's under the son's name. So all she has is some, you know, belongings and namesakes and so on and so forth. She says, oh, I'm not going to bother to make a will because I haven't got anything but just these things. Okay, she passes away, but she does have other children. What happens? Because she hasn't got a will, we are now going into probate.
No,
We're going into letters of administration. And so the government, the lawyers take over.
Well, no, the law takes over.
The law take
which
over.
Is, in our case, the civil code. It
Who
sets
pays
out
for that?
The heirs.
The heirs.
Yeah, you go
Right.
through a lawyer. The process for probate and LA is similar in terms of the application, the procedural application. The distinction comes in the how quickly the 2 applications proceed through the registry.
So if
And
she had a
documentation that you
will,
need to
it wouldn't
support
go
it.
to letters of
No,
administration.
it would go to probate.
It would
So
go
you
to
prove-
probate.
to prove the
Right.
will.
Okay, and that's quicker, I would assume.
Yes.
That's much quicker.
Yes.
And less costly than having to go through letters of administration, and time consuming, would you say?
I wouldn't necessarily say it's less costly. It is less costly because it takes so much shorter that you're in a position to realize the assets if you have immovable property, that type of thing, a lot faster than if it was letters of administration. I mean, can you imagine letters of administration where you have like 14 children, or you know, or something like that? Everybody has to get birth certificates to prove that they were the children of their parents, and you know, whatever. It becomes very complicated. If you have probate and you say that you're living next to this person, then the only person who is presenting themselves to the court is their executor. Or the executrix if it's female. That's it, right? And then it's the executrix that passes that property to the individuals. Much simpler.
You know, we're talking about all this, and it just, in a way, it just seems cold. We're talking about someone has died, and we are going to be distributing, you know, their possessions. But don't forget, people, during that time, you also have the emotions of losing that person.
Yeah.
And if that person was, you know, someone dear and close to you, you know, a parent, a child, you know, and you have to deal with that as well, especially if they did not leave a will, and you've got to go through all the, I mean, we really must, St. Lucia, we must think about protecting the people we love so that they don't have to go through all of that. When we pass away, we don't want to think of them running around. Most of the time, they will not know what to do, where to go, where to make a start. They're going to have to pay someone to do that. And most probably, they will even use whatever money you leave for them to pay for that.
Yeah.
You know, so let's stop sitting there and discussing and hearing all the stories that we hear of people saying, oh, this person died, that person, and then, you know, this person went to the house and they took this and they took that, and, you know, I mean, I have so many emails. Here's one in front of me here. My great-grandmother passed away. She had two daughters, one who was with my grandmother who died much earlier. The other daughter, my granddad took and sold all the property. There was no will. Did she have a right to do so? So basically, in a roundabout way, there was no will. So one person thinks, well, I've looked after them, or I've stuck around, so if they belong to me. We hear all these stories time and time again, but what do? We just, you know, hear gossip, talk, pass it on, and we're sitting here and we have not protected ourselves or protected the other people around us, so that doesn't happen. So this is a very serious concern, viewers, and please do something about it, okay? Now, when we come back from the break, we actually have Lana Wilson with us. She will tell us her story, and hopefully when you hear her story, I hope that will convince you that if you haven't written your will yet, because you're just assuming everything will be okay, you're just assuming your children will be able to look after it. I'm sure they're able to look after it, but is it worth them running around having to pay a whole set of money, whatever, just because you haven't written your will? Now, you've got 10 minutes to answer the questions to win tonight. Remember, you can find the questions on DelawFactorLive.com. It's a very important thing. We are offering you a Delaw Factor Live tonight, 50% off the cost of your initial consultation once you are going to prepare a will. We can't be more generous than that. We're going to get the names of 2 people, and all you have to do is tell us why you think you deserve to go and get your will done, and for us to pay 50% of that. You're watching Delaw Factor Live on DBS. Don't go away.